Emma Newman, and I'm the managing partner of Stowe Family Law. I deal with all aspects of family law, mainly finances, but an awful lot of children work as well. I'm an accredited member of Resolution in complex financial matters and children matters.
Now, the role of a family law solicitor, it can depend on what people's needs are. So, for example, I know that it can have a concierge role, if you like, that you can help people right from the beginning all the way through the process. Other people might be in a situation where financially they need to pick and choose a little bit. So could you sum up the key times when you absolutely should be talking to a solicitor?
I would say in almost every single case, the first step should be to go and see a family law solicitor, preferably somebody that's been recommended to you, preferably somebody that is a member of Resolution. It's arming yourself with information, and information is power. And a good lawyer will give you all of the options, and they will advise you as to what's in your best interest. Every case is very, very different. In most cases, I will be recommending that a couple go and try and resolve their financial issues and children issues in a forum like mediation, some sort of ADR. For some clients that might not be appropriate, and we might be suggesting that negotiating between solicitors might be better. And there are some cases where, not very many, but there are some cases where you might think you need to make an application to the court straight away, but they are definitely in the minority.
And perhaps you could share with us from your own experience with those that do end up in court. Would you say that sometimes people ending up in court who really shouldn't be there? It's their emotional, psychological anger. It's not a logical reason why they're there. That in theory they should be able to cut a deal and sort things out, but other things seem to have got in the way.
Absolutely, it happens all the time. You have a lot of cases where it should never get to court, and it's the worst possible place to sort things out. It's really stressful, it's really expensive, and the end result is really unknown. It's a bit of a lottery. But if you have got one party that is not being sensible, perhaps they're not being advised properly, perhaps, or they might be in person and they don't know what the law is going to deliver. They pursue it through. You've got no choice but to apply to the court just to get the right results.
So when it comes to the court, there's often many misconceptions around what it's like. People think, oh, the judge is going to listen to my story and I'm going to be shown to be right, and all kinds of interesting ideas about what it's about. Could you put people right on some of the sort of the basic facts of what they should expect if they do end up arguing in court?
Okay, so in relation to financial matters in particular, you often have clients who believe that they are going to have their day in court, and that's a phrase that's used very often, that they are going to be able to tell the court all about their partner's appalling behaviour and what has led them to that point. And it isn't like that. There are certain factors that a court takes into account when they're sorting out the finances of a marriage and how somebody's behaved within that marriage, whether they've had an affair. It's actually very, very rarely is it ever relevant. It's all about what the assets are, what the parties' needs are, and what is fair ultimately. And there is never ever having a day in court. I think people who go into the court process expecting that will come out very, very disillusioned.
Thank you. And also from a cost perspective, is there sort of, I know it's hard to put a number on it, but is there a sort of minimum that on average that if everything breaks down, if mediation is no longer pursued and you decide to go to court, what's the kind of expense that you should be expecting right from at the very least?
It's really difficult to say, because in financial proceedings there can potentially be 3 hearings if you end up at a final hearing, and in worst case scenarios you could have some interim hearings as well. But many cases sort themselves out at the first hearing, and your costs will be at the lower end of the spectrum. And when I talk about spectrums, the spectrums can be very different from case to case as well. You can have a really straightforward case with very clear assets, very straightforward assets. but you can have cases where the assets are really complex and take a lot of investigation, and that adds on to the costs. I think even if a case sorted itself out at the first hearing, I'd be very surprised if you would have costs of less than several £1,000s, and I'm talking sort of possibly 6 to 8. I don't think, I think that would be an absolute minimum.
Yeah.
But if matters go through to a final hearing where you've had potentially 3 hearings, we're talking about 5 figures in those situations as an absolute minimum.